So, freedom of expression is important in helping to achieve other human rights, such as political participation, as well as the right to health and food. But what happens when freedom of expression conflicts with those other rights? While freedom of expression is undoubtedly important in the realization of other rights in the International Human Rights Catalogue, it can also come into conflict with them. This is particularly so for the right to privacy, which may be interfered with when a news report touches on issues that, while they're of important public interest, are part of someone's private life. For example, a politician who campaigns against gay rights may have been in a homosexual relationship. The right to respect for one's reputation, which may be interfered with through reported allegations of corruption or bribery. The right to be free from hatred or discrimination, which may be interfered with through reports that place certain minorities in a bad light. Or the right to a fair trial, which may be interfered with through news reports on criminal proceedings that assume the guilt of an accused. Human rights law therefore recognises that limitations may be placed on the right to freedom of expression, in particular to protect the following: the rights or reputations of others, for the prevention of disorder or crime, for the protection of national security, for the protection of health or morals, for the protection of territorial integrity or public safety, for the protection of the confidentiality of information received in confidence, or for the protection of the authority and impartiality of the judiciary. Now, these are all known as the legitimate aims for which freedom of expression may be limited, and they can be found in paragraph 2 of Article 10 of the European Convention on Human Rights. However, states may not simply impose any restriction on freedom of expression by claiming one of these legitimate aims. Article 10, paragraph 2 of the Convention requires that any restrictions on freedom of expression must comply with what has become known as the three-part test. Under this test, any limitation on freedom of expression is legitimate only if it complies with the following conditions. First, any restriction on a right must be prescribed by law. Second, the restriction must serve one of the legitimate aims that I just outlined. Third, the restriction must be strictly necessary to achieve this legitimate aim. The first part of the test requires that any limitation is prescribed by law. This is simply a statement of the principle of legality, which underlies the concept of the rule of law. The law should be clear and non-retrospective. It must be unambiguously established by pre-existing law that freedom of expression may be limited. The European Court of Human Rights has said that to be prescribed by law, a restriction must be adequately accessible and formulated with sufficient precision to enable a citizen to regulate his conduct. The court decided this early on in the 1979 case of Sunday Times v. the United Kingdom, and the principle still stands today. It means that it should be clear how a law will affect the right to freedom of expression of, say, a newspaper, even if that newspaper may need to get advice from a lawyer on the finer points. The UN Human Rights Committee, which is a group of independent experts who oversee the implementation of the International Covenant on Civil and Political Rights, has added that any law that restricts freedom of expression must comply with the principles in the Covenant as a whole, and not just Article 19. This means in particular that restrictions must not be discriminatory and that the penalties for breaching the law should not violate the Covenant. If a law does not fulfill these conditions, then a restriction based on it cannot be considered legitimate. The second part of the test requires that the limitation pursues a legitimate purpose. The list of legitimate purposes for which rights may be restricted in each of the human rights instruments is an exhaustive one. For example, 7 such purposes are listed in paragraph 2 of Article 10 of the European Convention. These are the only ones that provide a possible basis for restricting freedom of expression. A state may not invoke any other reason to limit the right to freedom of expression. If they do, or if they invoke one of the listed purposes but the true purpose is something else, for example to hide corruption, then the restriction is illegitimate. The third part of the test is arguably the most important. Any restriction imposed on freedom of expression must not only be prescribed by law and pursue a legitimate purpose, it must also be necessary in a democratic society. This stresses the presumption that the limitation of the right is an option of last resort and must always be proportionate to the aim pursued. Necessary is a stronger standard than merely reasonable or desirable, as the European Court has held in one of its very first freedom of expression cases, Handyside v. the UK. The law must be precise and accessible, and it must be clear in the parameters that it imposes. In the case of Handyside, the European Court also held that a law may not confer unfettered discretion for the restriction of freedom of expression on those charged with its execution. In deciding whether a restriction is necessary in a democratic society, the European Court considers the public interest in a case. If the information to be restricted relates to a matter of public concern, it would be necessary to demonstrate that it was absolutely certain that dissemination would damage the legitimate purpose identified. The nature of the restriction proposed is also an important consideration. The US Supreme Court has stated that any limitation on freedom of expression must be the least restrictive possible. In the case of Shelton and Tucker, it held that, even though the government's purpose be legitimate and substantial, that purpose cannot be pursued by means that broadly stifle fundamental personal liberties, when the end can be more narrowly achieved. This is broadly the same approach favoured by the European Court of Human Rights. The UN Human Rights Committee has required furthermore that restrictions on freedom of expression may not put in jeopardy the right itself. This is clearly stated in General Comment 34 on the right of freedom of expression. Finally, you should be aware that in assessing the necessity of restrictions, the European Court of Human Rights allows states a margin of appreciation. This means that there is a degree of flexibility in interpretation, which is especially applicable if the restriction relates to an issue where there may be considerable differences among European states. For example, on the protection of morals. The margin of appreciation will be less when the purpose of the restriction is more objective in nature, such as protecting the authority of the judiciary.